Hello and welcome to the channel. If it's your first time, welcome. If you're coming back, it's nice to see you. So in this video I'm going to be talking about PACE, which is the Police and Criminal Evidence Act 1984, and also Archbold. So if you're preparing for your defence, if you've been arrested, and you see my other videos on what to do if you've been arrested, not only on the day you've been arrested, but what you should do afterwards. I've given 20 tips on what you should do immediately after your arrest. I refer to PACE and Archbold. Goes into it in a bit more detail. So who am I? I'm David. I was arrested for a criminal offence and I was on bail for 3 years before the case against me was dropped in a Crown Court in the UK. It was confusing and I was mad as hell, hence the two books that I wrote. First, the usual disclaimer. I'm not a legal professional and the thoughts, advice and reflections here are my own as a layperson. I'm just someone who's gone through the legal process for 3 years. I'm based in the UK. Much of what I say should apply for people overseas and in the US. Also, what I'm going to do is I'm going to let you do some of the research. So I'm introducing you to some of these aspects, some of the laws, but then you need to go away and do the research. So the Police and Criminal Evidence Act 1984, an act to make further provision in relation to the powers and duties of the police, persons in police detention, which might be you, the handling of criminal evidence, police discipline and complaints against the police. So it's an Act of Parliament which was instituted a framework for the powers of police officers in England and Wales to combat crime and provided codes of practice for the exercise of those powers. Now we'll be looking at the codes of practice a little later. So I'm going to start with this wiki introduction. Then I'm going to point you to the relevant government website and then we'll have a look at the actual codes of practice in detail, but not too much detail, they're too big otherwise. So the aim of PACE, which is this act, is to establish a balance between the powers of the police in England and Wales and the rights and freedoms of the public. So that's why it's important to you and how it might relate to your case when you build your defence. It mainly deals with police powers to search an individual or premises, including their powers to gain entry to those premises, the handling of exhibits seized from those searches, and the treatment of suspects once they are in custody, including being interviewed. PACE also introduces various codes of practice, one of the most notable being an arrest without warrant can only be lawful if the necessity test contained within Code G of PACE is met. It's been modified since and it is applicable not only to police officers but to anyone involved in the conduct of a criminal investigation, including revenue and customs, and to military investigations and so on and so forth. Okay, so that's the simple introduction to PACE. There are different codes of practice. Code A deals with the exercise by police officers of powers to search a person or a vehicle without first making an arrest. Code B deals with police powers to search premises and to seize and retain property found on premises and persons. Code C, which is what we're going to look at a little bit later, sets out the requirements for the detention, treatment and questioning of people in police custody by police officers. Code D, and we'll have a quick look at this as well, concerns the main methods used by police to identify people in connection with the investigation of offences and the keeping of accurate and reliable criminal records. Code E deals with the tape recording of interviews with suspects in the police station. Code F deals with the visual recording with sound of interviews and suspects. Code G deals with powers of arrest, and Code H deals with detention of terrorism suspects. Okay, so that is a simple introduction. Now, if you want to get access to these codes, you can go to the government website, gov.uk. This is Police and Criminal Evidence Act 1984, PACE Codes of Practice. You can go here. This is the overview. This is the summary. This page covers the Police and Criminal Evidence Act 1984 and the accompanying codes of practice, which establish the powers of the police to combat crimes whilst also protecting the rights of the public. Codes of practice, PACE, sets out to strike the right balance between the powers of the police and the rights and the freedoms of the public, Maintaining that balance is a central element of PACE. The codes of practice cover stop and search, arrest, detention, investigation, identification, interviewing detainees. And you can download the various versions of the codes. You can see them here. So I've just mentioned them earlier from the wiki page. Code A is about searching. Code B is also about searching premises. Code C, which is what we're going to have a quick look at, involves the detention and treatment and questioning of suspects. Code D, identifying people in connection with the investigation. Code E, recording of interviews. Code F, visual recording of interviews. Code G, powers of arrest. Code H, requirements for detention relating to terrorism. Okay, so this is a downloaded PDF from the Home Office of Code C of PACE, the code of practice for the detention, treatment and questioning of persons by police officers. That's the cover page, another cover page, another cover page. This is the contents. Now you can see it's a large document. It goes 100 pages or so, I think. So what I recommend you do is go to the government website, download this document and review it and see how it applies to you and to your case. So when I was arrested, my head was scrambled and I didn't really know what was going on. I was relying on the solicitor. But you do have rights as an arrested individual. If you're compiling your defence or if you're reviewing the matter, go to this document and see whether everything was done as it should have been done. So once you've been arrested, the following day, and this is what I tried to do a few days later, was to write down exactly what happened to me after my arrest and what happened to me in the police station. So I had a record. And then much later on, I found this, check what happened to me against what should have happened, because otherwise there might be failings which might undermine the police's case against you, how they treated you, how you were interviewed. That might be useful in compiling your case. The case might even be dismissed for instance, abuse of process if they didn't do this properly. And it can also inform any compensation. So if later on, further down the line, if you were ever to sue the police, then these are the grounds on which you would do it. But you won't be able to do this on the day of arrest. This is something to do later. So the contents. So we're going to whiz through this. I might dip into one or two. So there's a general introduction which overviews what this document should do. On point 1, all persons in custody must be dealt with expeditiously and released as soon as the need for detention no longer applies. This 1.2, this code of practice must be readily available at all police stations for consultation by police officers, staff, detained persons and members of the public, and so on and so forth. Custody records. Now this is something that was relevant to me, I found, because my custody record was incorrect as far as I could gather, and that showed that the police hadn't properly recorded my custody because I was rebailed many times. So when a person is brought to a police station under arrest, is arrested at the police station having attended there voluntarily, or attends a police station to answer bail, they must be brought before the custody officer as soon as practicable after their arrival at the station, or if applicable, following their arrest after attending the police station voluntarily. So was that done in your case? These are the things you need to check. So this gives you information on what should happen to you if you're arrested, when you're arrested, whether your record is correct and up to date. That is something that should apply to everybody. This is information on detained persons, the normal procedures. Then you have the detainee's property, what happens when they confiscate and seize property, the right not to be held incommunicado, so people can be informed of where you are and why you've been arrested. The right to legal advice, again, this is important. You have access to a solicitor, citizens of independent Commonwealth countries or foreign nationals, conditions of detention, so the cell must be in good nick while you're waiting, care and treatment of detained persons, cautions, when cautions are given, interviews, general. So 11.1a, an interview is the questioning of a person regarding their involvement or suspected involvement in a criminal offence or offences which, under paragraph 10.1, must be carried out under caution. Before a person is interviewed, they, and if they are represented, their solicitor, must be given sufficient information to enable them to understand the nature of any such offence and why they are suspected of committing it. See paragraphs. In order to allow for the effective exercise of the rights of the defence. Now, in my case, I could argue that I wasn't given the information. I go into my case in other videos, but The police were giving me very limited information. So again, you should think and ask yourself, were you given a reasonable amount of information of why you had been arrested? It continues. However, while the information must always be sufficient for the person to understand the nature of any offence, this does not require the disclosure of details at a time which might prejudice the criminal investigation. So that's up for debate. That's something for you to consider. The decision about what needs to be disclosed for the purpose of this requirement therefore rests with the investigating officer who has sufficient knowledge of the case to make that decision. But when they're asking questions, you need to know what the situation is. I was arrested. The police received intelligence on an offence that I had been alleged to commit, which was downloading indecent images. I didn't know anything about it. And they wouldn't tell me the intelligence. They wouldn't share the intelligence with me. And to this day, I don't know what that intelligence was. I mean, my legal team and I believe, as far as we can, it was a housemate who had a grudge against me and was known to the police. I'd been reporting the person to the police and to various authorities, and it was a human intelligence as opposed to credit card or other. So interviews in police stations, interpreters, questioning, special restrictions, reviews and extension of detention. So if you're detained for more than 24 hours, the charging. So I'll look at this one, paragraph 16.1. When the officer in charge of the investigation reasonably believes there is sufficient evidence to provide a realistic prospect of conviction for the offence, they shall, without delay and subject to the following qualification, inform the custody officer who will be responsible for considering whether the detainee should be charged. You should be asking yourself, did the police do this in the order and in the way they should? So it continues, the contents, testing persons for the presence of drugs. Then you have various annexes on strip searches, on the delay of notification of arrest and whereabouts or allowing access to legal advice, and so on. Annex C, Annex D, written statements under caution, E, F, Annex G, fitness to be interviewed, and so on. Okay, so that is something you need to go through this 100-page document and see whether it is relevant to your case and make a note. But this forms all part of your defence, and you should supply the information to your solicitor and barrister if it gets that far. Now we'll go to Code D. So you should do this with all the codes just to see if there's anything relevant that might help you. So Code D, Code of Practice for the Identification of Persons by Police Officers. That's another. And we'll just quickly go through these contents to give you an idea of what's involved. So again, this is probably a 60-page document. Introduction, general notes for guidance, identification and recognition of suspects. Have you been identified by an eyewitness? Was that done? How did the police gather the information? Was there an identity parade? Identification by fingerprints and footwear impressions. Again, there's a procedure which the police must follow. Number 5, examinations to establish identity and the taking of photographs. And was everything done in the correct way? Were you given the proper guidance? 6, identification by body samples and impressions. Annex A, this is further information on video identification parades. Annex C, group identification. Annex D, confrontation by an eyewitness. Annex E, showing photographs to eyewitnesses. Annex F, fingerprints and samples. And Annex G, requirement for a person to attend a police station for fingerprints and samples. This is something you need to have a look at, scan through, easily downloadable from the government website. Okay, so those are the 2 codes that we've had a quick look at. But there's one other thing you should have a look at, and that is Archbold. The wiki definition: Archbold Criminal Pleading Evidence and Practice, simply called Archbold, is the leading practitioner's text for criminal lawyers in England and Wales and several other common law jurisdictions around the world. This is it. It's published by Sweet and Maxwell. Now, it costs a fair bit of money. You can have a hard copy, you can have a CD, and you can look at it online. But you can probably get access to this at a library. Your solicitor should also have a copy. If you can get access to it online, that's probably very good as well. But again, you have all this information as a resource for trying to find out if there's anything relevant to your case and your situation. Again, you have more information here on the codes of practice. abusive process and entrapment, abusive process and private prosecutions, appeal, fitness to plead. So these are important to research. You might get some useful information on how it applies to your case. So that's really it. So I wanted to introduce you to those two things, PACE and Archbold. Those are the two things that you need to do some investigation while you're waiting for your next bail hearing or even a court date. You can check out my other videos, 20 tips video, which I'll link in the description, on what you should immediately do to start compiling your defence. I'll also go into, in other videos, a little bit more detail on defence preparation, documentation on how to present yourself in your case and how to link it with these kinds of things and the law. There's also one other official document that I'll introduce you to in another video. Those are codes of practice relating to the investigation of certain types of cases. So I went into quite a bit of detail. It was a 100-page document similar to the codes of practice, but it was a code of practice for the investigation of e-crime, because mine related to e-crime, and the police violated all sorts of procedures and neglected to do certain things, and that was a strong basis for my defence. Please subscribe, and if you're interested in helping me, then you can buy the books, obviously. You can find them on Amazon. I'll put a link in the description. So they're titled Mad as Hell Parts 1 and 2 by David N. Anderson. But there's also, I'm setting up a Patreon account, so if you want to support me and help me try and knock out more videos, that'd be a great help. Okay, thank you.
Let's go.